It's a phrase from popular movies. It's also a question that comes up in our daily life. The question is that even legal? We talk about the things that drive you crazy, the things you won't believe, and the things you need to know and understand. I'm attorney Bob Sewell, and this is the podcast, Is That Even Legal? Let's get started. Today's Oscars go to two amazing lawyers. No, we're not handing out Oscars. Is that even legal, listeners? But we do have two entertainment attorneys, and they are Bianca Goodloe, and she does transactional work. She structures deals. She works with talent and studios and moneymakers and makes things come together. And we also have Caroline Mankey, and she helps people resolve disputes after things go bad, and they never go bad, right? I mean, the Hollywood scene is always perfectly structured and perfectly civil, right? So welcome to the show.
Thank you, Bob. Good morning.
Now, the two of you have impressive resumes, and you've worked on really important Hollywood scenes. I know that Caroline has worked with, and hers has to remain more secret because she has to deal with the litigation side of things. But Bianca's worked on things such as the Lord of the Rings trilogy, Harry Potter, and she's even worked with celebrities like Johnny Depp and all the major studios. She's worked with a lot of these studios. So we have legitimate Hollywood attorneys here, and I'm very excited because when you go to law school and you ask what you want to do and become as a lawyer, people say stuff like, I want to be a Hollywood attorney. No one says they want to do what I do. I want to deal with dead people stuff. No one says that. They want to say they want to be what you are. So I'm super excited. Now,
thanks for having us.
I want to know how the sauce is made. You know, what goes into the sausage, right? And these deals are structured in very interesting ways. And it's big money. When a Hollywood studio makes a movie nowadays and they're going to put it out there, it's big money. Who invests in these things?
Okay, well, I guess I could jump in there. So there are a number of different kinds of investors and financiers because there are a number of different kinds of films and content. And it's a really diversified line of products that are coming out of media, ranging from small independent films that are oftentimes just fully private equity financed with the help of some tax credits and maybe some product placement plays and maybe some other in-kind contributions or some post-house deals. And then you run the scale of the gargantuan Hollywood films that are $100 million plus that are financed by the studios or a joint venture between studios or media companies. And they use their own internal financing and their credit facilities and they leverage against the existing intellectual property assets and libraries that they have.
Okay, so how do you actually make money? I mean, you're betting on whether or not people are coming to see it, and a ticket price. What I love about movies and these things is you can go see top quality actors for $15, right? And these are the best actors in the world. And I could see them on the big screen, these are the best music professionals in the world, and they're putting their music out there, and all the sound designers and engineers. And it's like you said, it's $100 million at times. How do they actually figure out how to make money? I don't know. It's beyond me.
There is a system of metrics in place that back in the golden era, it would just be someone's gut, right? It would be some guy smoking a cigar in his boardroom saying, you know what, I need a beautiful movie star and I need, a decent director, and we can figure the rest out because there's not that much content out there. And so these days, the business has changed, that it's a series of data analytics. Before you go out to cast, you work with various sellers that have discussions with various media buyers to see if I have a $10 million movie with X female actress and X male actor, How much can we sell Germany, Italy, and France for? How much can we sell Asia for? What's the worst case scenario that locks in our downside risk? And therefore, we can offer them this kind of a fee, which will justify this kind of a budget, because we can pretty much guarantee this kind of a return based upon what the buyers are telling us they're willing to pay.
And Bob, keep in mind that there are so many different streams of income with respect to movies. It's not just about the ticket office. There's streams of income for every different source of media on which you can play a movie or a television show or some hybrid of those two things. And not only that, there are merchandising streams of income. There's income from the soundtrack. There's income from the product placement and advertising. I mean, there's so many. There's just an infinite source of income that it all goes into the pot.
Okay, that's amazing to me. I mean, the fact that go
that
ahead.
doesn't mean that you can guarantee profitability. I mean, you can have all the right elements. You can have great talent. You can have great filmmakers, and even a master like Steven Spielberg can have a box office disappointment. It's very, very difficult to ultimately predict market behavior.
So there's someone out there, some statistician that says, when I have X actor, she or he, has a record of X box office hits, right? And they have their X fan base, and they bring in. That's really how it works.
I mean, that's a way to assess and try to mitigate risks on these kind of investments. And then also it's a numbers game, right? So if you're a studio, you want to put out things that are going to be stable performers, because they're predicated on known intellectual property. So there's already a conditioned marketplace out there that's familiar with the character, and that character can be merchandised. And if you have enough of those, then you can kind of take a risk on an outlier that is, a story based upon no IP. And you have to kind of create a new lore and educate the audiences to, a new set of stories, which ultimately, hopefully, will turn into a new franchise. But that's how you sort of leverage your risk.
That is amazing. Now, so that brings me to the next question. That's personal brand, right? And what's amazing is, if I am talent, right? I mean, we all know that one of the most sought after talent in Hollywood are redheads who do podcasts, redheaded attorneys, right? And then they are incredibly sought after. And let's say that there is a redheaded attorney who wants to get into this. He could sing, he could dance, he all sorts of great stuff. He can act. And let's say I start to collect these endorsement deals, right? And I have all the best companies, and they want me to design, and they want me to promote, and all these things, and they're worth millions of dollars, these endorsement contracts, because because of the popularity of this actor. So now I start to do crazy stuff, right? I start to tweet out nutty stuff. I start to say nutty things at promotionals, and I start to act crazy. And I might even say some racist stuff along the way. What's going to happen here to me, Caroline?
Well, most likely, most of the endorsement deals that you've done and most of your deals that you've done with any production companies and studios have a morals clause. And the morals clause allows that studio or production company or company that has sought you for an endorsement, it allows them to cancel the contract, cancel the deal, separate itself from you, potentially get damages from you for your breach of that morals clause. Basically, the morals clause requires you to behave in a certain way that is consistent with, a reasonable person's expectation of morality and common decency and so on. It's a little bit of a subjective standard, but in the example that you gave, it's not so subjective. Racism and some of those kinds of behaviors these days are not subjectively acceptable. So in that situation, it would allow the other side to get out of the contract and potentially seek damages against you. I'd also caution you with respect to one other aspect of endorsement deals, which is that one of the hot topics that we're seeing in celebrity litigation today are lawsuits against celebrities who have endorsed products that have failed. For example, cryptocurrency.
Oh, yes.
NFTs. There are a lot of celebrities who are getting blamed because they endorsed these products and the products failed, and investors are saying, hey, Tom Brady, you said this was a good product and I relied on you and I believed you and you led me astray. So as a celebrity who's endorsing products, you might want to take a second look at the product that you're endorsing before you enter into a deal and make sure you have some indemnification in your contract before you sign the deal. It's not just products that fail, but even product liability cases. Maybe you endorse some kind of, a car that has, a tendency to roll over, or the airbags don't work or something like that. So you have to be a little bit conscientious about what exactly you're endorsing and not just sign every deal because they're prepared to pay you some money.
Yeah, and you don't think about that type of downside risk, right? I mean, when you're endorsing X product, right? And it seems like a nice product, so I'm going to go out there and I'll collect my millions of dollars for that endorsement. But now we're seeing, Tom Brady was hit with a lawsuit for his endorsement of a particular crypto that turned out to be, managed like, drunken sailors, or the company was managed like drunken sailors. So it's, I never even thought about that.
We also have companies like the fashion brand Balenciaga.
Yeah.
I'm not sure if you've heard that in the news, but it's quite outrageous. And I don't know how that happens, but you affiliate with the brand. If you are a powerful brand like, the Kardashian brand, which legitimately think what you may about the family, but it's a force of nature when it comes to their brands and their products. And so if any of the family members affiliate with Balenciaga, and Balenciaga comes out with stuffed animal teddy bears that have S&M stuff on them, and they put that into an ad campaign, that's pretty egregious, and that's going to have a deleterious knock on your own brand. So, anyone that's affiliated with them in the past should consider their options and see, whether they want to seek some form of recourse for that.
Yeah, and that's fascinating because the company is worried about the actor's reputation, right? And if I'm the company, I want to make sure that the morals clause binds that celebrity. So if they do crazy crap, I get to say, I'm out. I have canceled this contract. I'm no longer with this person. But in the case of Balenciaga,
there should be symmetry.
Yeah, is there symmetry? Is that typical to have symmetry?
If you know what you're doing, there should be, yes.
because that was one of the things that happened to one of the Kardashians. I can't remember which one, but she had endorsement deals with this company, and they came back and said, "Hey, aren't you affiliated with this weird company that did this weird stuff?" And that damages her brand.
Yeah, and historically, I don't think we have seen morals clauses that go both ways and that also bind the company to some kind of moral standard. But I think we're going to be seeing those more and more because of these types of lawsuits and claims.
I think it's a matter of the leverage you have based upon the talent that you're representing entering into the deal.
One of the things that's interesting is with morals clauses is we have shifting morals, right, in this country. What was acceptable 20 years ago is not acceptable now, right? I mean, and I hate to say that I've gotten to a certain age, but I'm getting to that certain age when I say, well, what happened back then doesn't really apply now. How do we deal with that in the contractual situation? Because, let's take Kevin Hart. Kevin Hart said some things he regretted. It pops up later when he's been asked to do the Oscars. And now we have this situation where he ends up being asked to leave the Oscars, or he leaves the Oscars. He's asked to apologize again. What do we deal with this shifting values of our country?
Well, I think that contractually, the language is a little bit, it doesn't define exactly what is acceptable and what is not. It's usually a reasonable person standard. And that reasonable person standard shifts as the time does, and as the common perception and subjectivity also shifts. And so should a matter or a dispute like that go to court, a judge is going to look at, and a jury is going to look at, what does a reasonable person in today's era think is acceptable or not. And that's usually how those kinds of disputes are resolved. But that's a very gray standard, isn't it? It's not black and white. It doesn't allow you to know exactly what you can and can't do.
Interesting, the perils. What do you do? I mean, what are you looking to put in a contract like that, Bianca?
Well, again, it depends which side I'm representing. So if I'm representing the actor, then I would want to, instead of try to micromanage the definition of what is socially and culturally, politically correct and permissible at the time, I would rather wrestle a slightly different alligator, which is the application of the behavior. So if I have behavior or statements or whatnot outside of the context of this particular product, or outside of the context of this particular event, or this particular film, or this particular time period, then it falls outside of anything that a morals clause would apply to. So again, that's a little bit more finite of what to sink my teeth into. If I could put brackets around the period of time whereby my client is being evaluated upon the behavior, rather than trying to define what exactly is permissible behavior in a contract.
Yeah, it's interesting. I want to go back to the money for a second, because we how we view media is changing, right? I mean, it used to be, and the styles of media, it used to be we had big screen actors and they told big screen stories, and there was a particular type of story. And then you had small screen actors and they did the stories on the TV, and they were particularly wrote in a very formulaic way. And never the two did meet. And that was it. I mean, you had of course, your stage actors. But now we have big screen actors on the little screen, and we have streaming, and we have
influencers
that
are neither actors on TV or film, but nevertheless media presence.
And we have this story. We got the story of Scarlett Johansson. Apparently, she has the movie Black Widow, and she alleges that Disney breached the contract because they went to streaming too soon, and the result was, she said, she made less money. They end up settling the dispute. What's going on here, Bianca?
Okay, well, so the less time you have in theaters, the less box office you're going to make, because once you open additional downstream distribution windows, that particular initial window gets cannibalized. Right. Mm-hmm. So ultimately, when they settled, I had no part in that particular transaction, but one would presume that they would settle somewhere based upon what box office was anticipated to be had they kept it in theaters for the full intended run. And that was a wake-up call for a lot of transactional attorneys to ensure that every possible distribution outcome is properly negotiated and monetized. Because you have unexpected things like COVID, and you've got other unexpected market behaviors that, allow the studios don't want to be, or any media company doesn't want to be pinned down to any one form of distribution. They want to be able to iterate and to optimize the products that they have based upon market conditions. And so we don't want to encumber that in any way. We want to maintain the enthusiasm of the distributors to push the product. But that means that we have to pre-negotiate the terms of every distribution eventuality. So if it goes theatrical, let's have the full negotiation here. If it goes streaming, if it goes PVOD rather than initial SVOD or whatnot, you have to have all of those negotiations.
And the reason. Go ahead.
I'd just like to add, from a litigation standpoint, what basically happened here was an eventuality occurred that was not contemplated when they were negotiating and drafting the agreement. And so one could look at that situation and say, oh, well, too bad, Scarlett, you didn't contemplate that. We don't have any obligation. But there is an implied obligation in every contract. It's called the implied covenant of good faith and fair dealing. And if the purpose and spirit of a contract is violated, then one could make a claim that the party has violated the implied covenant of good faith and fair dealing. And so, if the intention of this contract was that there was going to be a theatrical release, and the theatrical release was going to be the primary source of income or the largest source of income, and that step was omitted by a decision of the studio, then Scarlett potentially had a claim for breach of the implied covenant of good faith and fair dealing.
Well, but why wasn't it anticipated? Why would she not think, hey, it's going to go straight to streaming, or it's going to have a very short period in the movie theater? What happened? Caroline?
Well, that's a good question. I'm sure she had very good lawyers, but at that point in time, I presume that that deal was negotiated before COVID, and no one had any expectation that a movie like that, a big blockbuster movie, would go straight to streaming and skip the theatrical step. Historically, we have always had unanticipated eventualities arising from new forms of content delivery. I mean, that has gone back for years and years to the Betamax and CDs and DVDs and all of these different ways of delivering content. So presumably lawyers are getting smarter about how they negotiate and draft agreements to be inclusive for all types of eventualities. But with every passing occurrence, when something like this happens that nobody anticipated, it illuminates the issues that need to be addressed at the outset of every contract negotiation.
Yeah, it's absolutely fascinating to me because, when I remember when COVID hit and our clients are coming in and they're to the office and they're having problems, for the first time in most everyone's legal career, we started to look at that clause, that force majeure clause, right? The acts of God clause. Well, when this crazy thing happens, maybe this clause kicks in. And they were always throwaway clauses, right? People throw them in there and they never gave them a second thought. And then COVID happens, the world flips upside down, and then suddenly we're like, maybe I should have carefully drafted that force majeure clause. Maybe I should have rethought that clause. And that's really what I hear is happening in the industry.
Well, what happened to a lot of the transactions that I was working on after the initial shock of COVID, when the industry found a way to start the wheels of production moving forward again by taking certain COVID-related health measures on set, et cetera, et cetera. So not only myself, but everyone that I was dealing with started to specifically carve out COVID and excluding it as an event of force majeure. So it couldn't be used as a sword or a shield because we were kind of having practical workarounds for it in terms of production. But also, we were talking about the Scarlett Johansson movie. It wasn't just a one-off, by the way. The entire slate of 2021 Warner Brothers theatrical releases were concurrently released, were streamed on HBO. I mean, that is kind of a move that shook the world, the entertainment world.
Yeah, because the traditional model is first you go to the theaters, and after it's been exposed to the market in the theaters for an X period of time, or we start to see an X drop off, then we set it for streaming or video, whatever the outlet becomes. Then we set it for that schedule, and we see another uptick, right? So it turned it on its head. So I want to talk more about money and the reason that even got us thinking about doing this episode was I'm listening to Matt. I love celebrity gossip. Okay, it's one of my pastimes. I once went on Fox News to talk about the Britney Spears conservatorship, and I thought I died and went to heaven. I said I'm here talking on the news about Britney Spears and the law. And I said, that it can't get any better than this. And so, so I'm watching Matt Damon, and he's describing how he was approached for the Avatar series. The director, Cameron, whatever his name is, he comes up to Matt Damon. He says, "Hey, can you come and be part of Avatar? And I'll give you 10% of X, royalties or whatever, production." And he says, "Well, that's an attractive offer, but I got to finish up, this Bourne movie, and your timing doesn't match with my timing." And he says, I have to say no. And then, of course, Avatar was wildly successful, and he says it was the biggest payday he walked away from. How does that work? How do you, as an actor, put yourself in a position that you're going to enjoy the upside with the investors? Because investors typically take all the risk, and in that scenario, Matt Damon would have been taking some risk too.
Well, you have to appreciate the fact that there are lots of different value containers from which talent is paid for any individual film. So you've got your fixed fee compensation, which is something that's payable directly from the budget. You've got your traditional contingent compensation, which is profit participation. Then you've got your box office bonuses, assuming that this will go to box office. Then you've got your streaming bonuses. You could have your awards bonuses. And the way an actor, again, depending on the leverage they have based upon the strength of their brand name, their definition of net profits can be very different than the investors or other actors or the directors or the studios. That could be front loaded, that they get a percentage of $1 from the box office. We see those kind of deals much less frequently than we did back in the end of a different era. But that's not to say that they don't exist entirely anymore. But, it depends on what the studio and being the investor or the investors are willing to agree to. If the difference between having a Brad Pitt in a movie is the difference between five-fold multiplier of investment and a break even, then it's worth moving their profit participation way up to the top of the waterfall.
Caroline, everyone in Hollywood is honest. I know they are. I mean, those people are beautiful, and beautiful people are always honest, right? And so there's no need to have people watch the watchers, are there? How do you know your talent gets paid?
Well, to Bianca's point, because there are so many different sources of income for talent in a movie, there are lots of opportunities, let's say, for error or oversight.
Oh, okay.
Right?
Yeah, that's very politically correct.
Let's put it that way. When you're doing the calculations, there's a lot of human error involved. Sometimes, for whatever reason, when you're calculating, these are accounting issues, and we all know there's a potential for accounting errors, and oftentimes talent may think that there's been an accounting error or oversight or something more nefarious, and so typically talent has in their contract the right to examine the studio's books and records or the production company's books and records. And they can send in an auditor who can audit the books and records and basically double check and make sure that the talent is getting paid all of those sources of income to which talent is entitled. And oftentimes that leads to disputes over the definition of net profits or gross profits or different contract terms, what should be included in them, what shouldn't, whether those elements are all properly being paid and calculated, and those are very, very common disputes, and a tremendous source of the litigation that happens in the entertainment world.
And so the deterrent that you would have in a contractual provision would be if there's an underpayment owed talent or anybody in excess of X, like 5%, then the cost of the audit would have to be borne by the distributor, and so that can add up. I mean, audits are very expensive. Also, what I recommend clients to do is having no suspicions of any miscalculations of definitions, just
Okay.
immediately give notice of audit. Like the second that you have the agreement in place, immediately send a notice of audit, or immediately when there's a release of the content, because that puts the distributor on notice that you will be watching. And that sometimes, I mean, it's not a guaranteed fix, but it puts enough teeth into the provision to let them know that eyeballs will be supervising their bookkeeping practices.
And that's an excellent strategy, because oftentimes the contracts have limited periods of time in which you can assert any kind of objection or audit notice. And if you go, say it's 60 days, and if you don't send that notice within 60 days, you waive the opportunity.
What a mess. And what's interesting is the actors, they don't know this stuff, right? I mean, they have focused their craft on acting, not the law. And so they need people like you to manage this complexity, this web. One of the webs that is fascinating me right now is how we're moving from the theatrical setting to the streaming setting. And the streaming setting is a lot more dense. Like, we can't measure it in the exact same way you're measuring theatrical dollars, right? Because on the streaming setting, I might be bundled up with a bunch of other streams of income and other movies that maybe it's not as easy to look inside the crystal ball. What's going on? What are we doing?
Crystal ball, it's a black box.
Yeah. How are people looking at this? What should we be anticipating in the changes in the law?
Well, okay, so one immediate effect when streaming became mainstream was how residuals were being treated. By way of example, if you have the most successful film on Netflix, the most watched, you don't know the metrics exactly, but they'll tell you this was the number one watched, number one, number two, number three, top 10 of this week or this year. You are not going to get any more residuals than the least watched film, because they prorate that based upon the number of shows, not the volume of viewership of a particular piece. So that breaks in the favor of less watched films, and it hurts the most watched film participants.
So they aggregate revenue and then distribute based on who was the most popular?
Well, this is not a contingent compensation. This is residuals.
Yeah.
So this, for example, like a writer that is part of the WGA is entitled to certain residuals based upon the performance of the film. SAG has its own residuals. The Directors Guild has its own residuals, and they're tied to certain metrics of a movie. But those metrics got changed when the streaming platforms entered into the marketplace. It became less of a meritocracy.
Right, but the runaway hits are still going to be the ones where those writers, those producers, those actors are getting the next jobs.
Very true.
Or the show is continuing. I mean, look at White Lotus. That's been such a breakout hit, and it was conceived during COVID based on what a lifestyle, what the writer Mike White's lifestyle was like living in Hawaii at the time that he was writing the first season, but then it also allowed them to have a closed set in which they could film the show, the first season of the show, with a closed set, which was a safer environment based on the COVID circumstances. And now we're looking at season 3, and it's just such a huge hit, and it's just taken on a life of its own.
Okay, I need you ladies to spill the tea, okay? What is the greatest piece of Hollywood gossip you have? No, okay, I'm not going to ask you that, because you probably have some really good stuff. But I do want to know. I want to know what are some of the craziest contract provisions you've ever seen?
Like on the writers, like little sort of specific.
Well, you have. There's folklore out there. I have no idea if it's true that a certain band required that all the
Green M&Ms.
the green M&Ms, and it's they're all removed from the M&M ball, and that was their litmus test to see whether they had actually followed their punch list. And I have no idea if it's true. It sounds fantastic, but it's not true. What have you actually seen though? Or I don't know if it's true. So what have you actually seen? Something that they
psychic. Part of the team that travels with talent has to include a pet psychic.
Okay, is that for real?
That's a great one.
You're not making this up?
No, that was part of the Ryer. Yeah.
Wow.
Yeah. I see a lot of like electric vehicles now when you go to set. People are specifying that they want a lot of this is like very ESG related asks, like environmentally friendly, make sure that there's like, vegan stuff on the set, that the cars are electric, that maybe they're, what else was there? Time for meditation on the set. It's more kind of like, it's more lifestyle asks.
Okay.
A lot of special training equipment or exercise equipment on locations. You get that a lot.
But Caroline,
yeah, I would agree with that. But Bob, that leads me to a point, which is that, with respect to the crazy asks, one point that I think is sometimes underrated in negotiating contracts is the arbitration provision of a contract. The arbitration provision, it exists in some contracts, not in others, and it allows the parties to a contract to, in advance, elect to resolve any disputes through arbitration. That's one of those provisions that, like you mentioned earlier, the force majeure provision that is often overlooked in the negotiations. It's just something that people throw in sometimes without even really thinking about it and without realizing how important it is, because it can really change the nature of any litigation or escalation of a dispute, and it can change it in critical ways. And with respect to the crazy terms or the crazy behavior of talent, an arbitration provision can be critical because it can allow any disputes to remain completely private, not become part of the public record, to remain completely confidential. And for high-profile talent, I think that there are a lot of instances in which they would want to keep their disputes completely private, completely confidential, and not have all of their dirty laundry aired in public.
No, so important because
also,
of the
I'm sorry to jump in, but I just realized that arbitration is binding, right? So if you get an arbitral determination that you feel is biased, there's absolutely nothing that you can do. You can't appeal it to a higher venue. And again, I'm not the litigator here, but somewhat recently I heard of this seminal case that involved Monster drinks.
Mm-hmm.
That, okay, so to contextualize, when you go to an arbitrator should be unbiased, impartial, dispassionate, and look at the facts and exclude everything else. But in fact, arbitrators have clients and they have repeat clients.
Yeah.
And the studios oftentimes are the largest client of a particular arbitral tribunal. So they know who butters their bread. And that may have an impact on the determinations of their binding, non-appealable judgments. And so this particular Monster case, you, I'm sure, know much more about it than I, but allowed for there to be a little bit of sunlight on disputing whether bias exists and whether a case can be overturned, which would then have a knock-on effect to revisit other prior determinations by arbitrators and arbitral tribunals that could have had that bias implied.
Yes.
Right. That's one of the very, very, very narrow areas in which you can reverse an arbitral award.
Yeah, and
that's a big step in the right direction, I think.
Manifest misjustice is often what we hear on those things, but it's so important. Like, in arbitration, if you are just a regular Joe Schmo, no one's looking up your case. So if I go into court and I say, and I air my dirty laundry in court, and I'm just a regular Joe Schmo, no one cares. No one's looking. No one knows. there's thousands and thousands of cases in the metropolitan areas, tens of thousands every year. But if I am Mr. Celebrity, they're going to know every last detail, every last word that was said. And everyone has dirty laundry, and we all love dirty laundry. We love to hear the gossip, and they will hang on every single last one of those words. So yes, arbitration's got to be super important. So, and we talked about brand a lot. We've talked about, damaging a brand and morals clauses. But what about brand rehabilitation? Is it possible? How do we deal with that?
Well, it is possible. Interesting segue, since we were just recently talking about the arbitration confidentiality and sort of the closed arbitrations, because most people don't want to shine any light on highlighting the warts and all, which could damage the brand. But if once in a while you get some case that, like the example of Johnny Depp, where against everyone's better advice, he shined a lot of light on a lot of things with Amber Heard in their litigations. And ultimately, I think that it really helped his brand. I think he walked away from that grueling experience with a real renewed renaissance for his brand. And, I'm working with him right now on a film that is being shot outside of the studios because he's taken a breath. And he's also shooting it outside of the United States, taking a breath. And he's not on camera. He's actually going to be the director of a film that I can't talk too much about. But I think it gives him the opportunity. It has something to say about how critics and the public and the system has wrongly misjudged him. And so this is his artistic way of having the last say. And I think that will continue to rehabilitate his brand.
Yeah,
in a way that others have not been able to achieve.
Yeah, and I there is something that very American in that story, right? I mean,
everybody loves an underdog.
Yeah, and if you held me to the person I was when I was 16, I mean, you would smack me every day you saw me. I mean, I'm a different person now. I'm literally a different person now, and so we want to be able to believe that people can change, they can morph, they can forget who they were, become anew, right?
Well, the public also loves celebrities, and we're very forgiving of celebrities. I mean, there have been so many celebrities in history who've, done bad things or done things that are not popular or, had impact to their reputation. And we always forgive them. And, in fact, the publicity just increases our interest in them. There's really, no bad publicity, some people believe. So,
right.
Just the attention on someone can impact their reputation and their visibility in a positive way.
But also, if there is bad publicity that's truly, truly hard to recover from, the cycle of the newsfeed is so rapid these days that it's, you pass the hot potato to the next individual, the pressure's off of you, the story is shifted, and someone else has done something even more egregious. So
yeah, exactly.
Don't look at me. Look at Frank. Look what he did, right? Yeah.
Over here, or not over here.
My final question is this, and this is totally serious. Can you get me in a movie? I'll settle for a dead body. I'll play the dead body, okay? Can you do it for me? Can you get me the hookup?
I know some people.
All right, ladies, thank you for coming on the show. It's been very interesting, and I've really enjoyed talking with you.
Thank you, Bob. It's been fun.
It's been my pleasure. Thanks so much.
Thanks for listening to Is That Even Legal? Remember, this isn't legal advice. If you have a legal question for yourself, reach out to an attorney. Remember that we're fun, we're lovable, and we are here to help you. To my listeners in 62 countries across the world, if you have something you want to explore, email us at producer@evenlegal.com. And don't be shy about leaving a review for this podcast on your favorite podcast forum. See you next time.